Welcome to this class on pattern cross-examination. My name is Michael Waddington, and I'm a trial attorney. And in this class, I want to teach you some techniques that I developed over the past 22 years as an attorney that can be used in all types of cases, whether it's criminal, civil, and in the civil cases, it can be used for family law, anything like immigration, personal injury, workers' comp, med mal. I want to begin this class with this quote by Epictetus. He is a Stoic philosopher, and it goes like this: "It is impossible to begin to learn that which one thinks one already knows." And the reason I like to start off this class and many of my other classes with that quote is because I'm teaching lawyers. I'm teaching lawyers, some of whom have no experience, some of whom have been practicing law for 50 years. And whether it's the first year lawyer or the 50-year lawyer, we have to remember that there's always more to learn. You can always learn something from different people, different perspectives, if you keep an open mind. So as we go into this class, I hope and encourage you that if you have, whether a day or 50 years of experience, you put that aside and just listen for any techniques, 1, 2, 3, or 4, or maybe many more that can help you and you can implement into your law practice. Because this is something that's worked for me and it's helped a lot of other people that I've mentored and worked with over the years. So what is pattern cross-examination? It is a highly customizable, reusable toolkit of cross-examination questions and topics that can be used for a variety of subject areas and witnesses. In other words, it's groups of questions that can be developed and used and repurposed and used for a variety of cases. For example, you can use pattern questions that you develop in a child custody case or a criminal law case. You can use that in a personal injury case. You can use the same system and some of the same materials in a variety of cases. And some of these questions, they come from your experience or questions that you learned and developed from one case or another, or they were passed down to you, or that you heard someone using, or they can be created. And in this class, I'm going to teach you how to create questions, pattern cross questions, and create them in a way that is sustainable and reusable. So when I say a toolkit, I really mean it. You know, it's like you have a folder on your desktop called pattern questions, and you can break them down for impeachment, for example. Let's say you're a criminal lawyer, whether you're a prosecutor or defense lawyer, you could have impeachment. You can have snitch impeachment, a law enforcement impeachment, the accused impeachment. And inside of that impeachment folder, let's say snitch impeachment or, cooperating government witness, you could have 10 different types of pattern cross-examination questions, chunks of questions that you can ask someone who's a cooperating government witness, depending on what you're trying to do. You can do the same thing in a medical malpractice case. Let's say you do a lot of med mal or tort type cases, and you question a lot of doctors. Let's say you focus on specific injuries. You can develop a series of questions that you use in this case and move on to the next case and modify it, tweak it, continually expand it to the point where you have a library of questions. And so you don't have to waste so much time and spend so much time reinventing the wheel with each and every case. I look at pattern cross-examination questions like Legos. You can do a lot with a bucket of Legos. You can just build a brick or you can build a city. These are Legos, but for cross-examination questions and topics. So imagine having several buckets of Legos / cross-examination topics at your disposal. And we all know what we can do with Legos. You can build a car, you can build a wedding scene, you can build a city. The same thing goes with pattern cross-examination questions and topics. So you can build a wedding scene, you can build a car, you can build a city, you can build whatever you want. The same thing goes with these questions. You can mix and match them, you can batch them together. You can do quite a bit with these pattern cross-examination questions once they are developed. So pattern cross-examination questions can be used in all sorts of cases. You can use them in personal injury cases, criminal law, workers' comp, family law, any type of civil litigation, any type of litigation where you're cross-examining a specific witness. And if you do this long enough, like I've been practicing law for about 22 years, and we see a lot of the same types of witnesses. You see a lot of the same types of questions that are being asked over and over and over again. And a lot of lawyers that I'm friends with, before they cross-examine each witness, they sit down really from scratch and they start developing these questions. Now, maybe that works for them, but I do know this, that when I've developed a lot of my pattern cross-examination questions and shared them and taught them and showed and shared these techniques, a lot of the lawyers that I taught it to were thankful because it helped save them a lot of time. It made their cross-examinations much more effective and allowed them to pivot while the witness was on the stand or on very short notice. I've done this too in my cases where if I have a witness that I'm about to cross-examine and that witness says something about like DNA, they say something that was not expected, I can quickly go to my database of pattern questions and I'll have a whole series of, for example, DNA transfer. I could go to those questions and be ready to go with high-quality professional questions with the impeachment material attached, like if it's a journal article or a textbook, ready to go right then and there, literally on the fly. And like Legos, these questions can be recycled and reused and repurposed over and over again. I recommend you start developing these questions now, particularly if you're a newer lawyer who might have 30 or 40 years ahead of you in practice. Imagine 20 years into your practice where you would have a massive database of questions. It would make your job a lot easier and it would save you a lot of time and energy going forward over the years. So here's the outline of this class. It's a 55-minute class, and we're going to talk about how to find resources, how to convert them into cross questions, the resources, using the learned treatise, impeachment, exception, DNA example, and then I'm going to give you a couple examples of various impeachments in different types of cases. Now, before we begin, I want to just give you this origin story of where this idea of pattern cross-examination came up. So I want you to go back in time to 2008. I had been a JAG lawyer an Army JAG lawyer, and I was 2 years out of my JAG tour of duty, and I got hired on a case in Okinawa, Japan. And I was a fairly young lawyer. I'd only been in a private practice for 2 years, and I had approximately 8 years of legal practice under my belt, and not all that was in criminal defense. And so what ended up happening is I got hired on this case, and the trial was in Okinawa, Japan. It was a Marine accused of committing a bunch of crimes. He was facing about 100 years in prison, and it was various crimes, mostly sex crimes, some violent crimes, things of that nature. And this was a case in Okinawa where my client was facing significant jail time, like over 100 years in prison for some very serious crimes that were supposedly committed. So off I go. I fly over to Okinawa, Japan. It's quite a distance from the United States, as you can see on the map and as you know, but it's also quite a distance from Japan. So how you get there is you have to fly into Japan, then you have to switch airports. Sometimes you have to take a bus from one Japan airport in Tokyo to another, and then get on another plane and fly another 4 hours. And so when you're there, you're very remote. It's a chain of islands, and the main island there is not that large. It's very congested and very small, very beautiful place, but you're in the middle of nowhere when it comes to getting expert witnesses and legal resources at your fingertips. So I go off and do this case. And here are the areas that were relevant in that case where expert witness testimony came up. Trace evidence. We're talking about lotions and creams and things like that. They were trying to connect one lotion to a bottle of lotion, another bottle of lotion to try to make connections. We had DNA. We had YSTR DNA and a full DNA profile. We had digital forensics. There was issues of whether or not images were downloaded and shared. We had a forensic psychologist involved. And there was an investigator that did some shady stuff in terms of evidence handling and interrogations. And then we had a sex assault nurse examiner or a SANE that was also involved in the case. So what we did, and by the way, the military rules follow the rules of, it's called the military rules of evidence, but it's almost identical to the federal rules of evidence. We call it the MRE. In the federal court, it's the FRE. It's almost identical. And a lot of the same procedures apply in the two different court systems. So they're very similar. It's military, but it's also very similar to the federal criminal system in many ways in terms of getting evidence and things of that nature. So what we did here in this case is we asked for expert witnesses like those the government had. And that's how it works, right? Like I don't have to go find 7 experts and fly them over to Okinawa. The government will appoint these experts. You have to ask them for permission. And so we did. And here's an example. Boom. Strongly recommending this approval. The Marine Corps recommended disapproval of all of our witnesses, although they had all these same experts on their side, which, by the way, if we would have lost the case, which we didn't, the case would have gotten overturned for these grounds. But, they're Marines, they're hard chargers, so they're like denied, 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 denied. Although we asked for them, we justified why we needed them and whatnot. And then the general turns around in January 2018, denies all of our witnesses because we, quote, failed to justify the necessity of the expert. And in that case, that's just one of the experts. So I'm over in Japan and I'm sitting there with my client, and the government brings witness after witness to testify about things like DNA, things like, Vaseline and the chemical properties of Vaseline that was found on this object and this object in this bottle, powder found on condoms, lubrications, a bunch of different things, sexual assault topics, computer forensics. And I'm sitting there alone with no expert to rebut what they're saying. So I told the judge before I did that, I said that I can't effectively defend my client because I need these experts. And he says, well, they're experts. Experts are unbiased. And so we went and tried to interview all these experts. That's not the way the appellate courts look at it. We tried to interview these experts and they're like, we're not on your side. We're not biased. We're not even talking to you. So what did I do? I went over there and I brought a series of books. Like I had a bag, an extra bag within my suitcase filled with textbooks that I got off on Amazon. And I'm going to teach you how to use these. And this book here, for example, is a textbook, and you have different ones. You have like shooting incident reconstruction. I've used that in murder cases where I didn't have experts, shooting incident reconstruction. There's books on medical books that I'd used. I used books on drugs and all sorts of materials. So what I did in this court is I systematically cross-examined their experts using the learned treatise exception, which is you learn about it in law school and for the bar, but you never really ever see it. At least most people I know don't even know how it's used. And I'm going to teach you how to use it here in a minute. So I cross-examined the witnesses. I impeached them with textbooks and journal articles that I got online and that I brought with me. And in the end, we won the case. What does that story have to do with anything? Well, I'll tell you. After that, my wife and I sat down over the past 6 years and we wrote a series of cross-examination books. I'm not selling these books. They probably wouldn't be helpful to 95% of the listeners. These are for specific types of criminal defense lawyers. But we converted all of these topics and all of these pattern cross questions into sections broken down by topic, by point. And it literally has the questions with the citations and the pages and everything right there, so you can impeach the witness if they disagree with you. So that is my background, my origin story as to why I probably have a few things in here that you can learn. When doing a case, you always attack what is weak in your opponent's case and you avoid what is strong. You focus on their weaknesses, attacking them, exposing them, and making the case about their weaknesses and focusing on your strengths, because usually their weaknesses are your strengths. You do that, your opponent ends up in a defensive position, and it's very difficult to win a case from a defensive position, especially when the burden is on you. Now, you have to remember that trial is a battle of credibility. The most credible lawyer, the most credible witnesses, the most credible evidence ends up gaining advantages and in the end has a higher likelihood of winning in court. I'm not saying you're going to win every case because you're credible, but it doesn't hurt. People don't like to vote in favor, jurors don't like to vote in favor of witnesses and lawyers that they hate. If you give them a reason to not vote in favor of that lawyer, let's say you're the opposing counsel, you want them to like you want them to trust you, you want the jury and the judge to rely on you as you're not a witness, but you want them to rely on you as someone who's bringing credible evidence that matters in front of the panel. And so when you stand up into your closing, people listen to you, the jury and the judge listen to you, they believe you, they rely on you. There's another class I taught called Controlling Hostile Witnesses. This slide is part of your package. If you sign up for this course, you will get these slides. And if you didn't get them, you can contact me at the end. You'll see my information. But you have to control hostile witnesses. That's opposing witnesses, expert witnesses that are testifying against you. If you don't know how to question them and control them, then no impeachment is going to work. No cross-examination is going to work. So you have to master the basics. So here we go. When it comes to pattern cross-examination and you're dealing with experts or people of authority, or it doesn't have to be an expert witness per se, like a doctor. It could be someone who's a law enforcement investigator, a tax auditor, a guardian ad litem, someone in some sort of official capacity that has power, that's up there testifying against you, and they have some sort of sense of authority. What do? Well, first thing you need to do when you know that person is going to be a witness is to do your research. Do your homework. Start with books, start with articles, start doing some research online. Don't just immediately call an expert. So if you're doing a case that involves a forensic psychologist that's going to be on the government side, don't immediately call another forensic psychologist. You got to be careful because some will say whatever you want them to say at first to get hired. You have to do your due diligence and figure out what the issues are before you contact an expert. Years ago, I did a murder case in Hawaii, and it came down to whether or not my client or someone else pulled the trigger. This is a case that happened in Iraq. And I went over to do this trial with a very well-known expert. This person is very well-known in the media, got paid a ton of money, and came over telling me what I wanted to hear because the case was in the news and in the media. So this guy comes over, wants to shop all over Hawaii, wants to go to the beach while we're trying to work. And when we finally start working, he changes his opinion. Maybe your guy did do the shooting, maybe this, maybe that. He became very wishy-washy, whereas before he got on the plane, he was adamant that, based on this evidence, it's impossible that your guy is the one who pulled the trigger with the M4. And so the government was calling this famous ballistics expert. So again, I went out like I always do. I go out and buy these books. If you can find the book of your expert, do it. If your expert that you're going to be cross-examining wrote a book, an article, do as much research on them as possible. So in this case, what I did is we brought this pathologist, and aside from wanting to shop and eat and everything like that, he fell asleep during the government pathologist's direct testimony against my client. And I turned around and looked at my expert, and he was sleeping in the audience. Maybe he was jet lagged. I don't know. But the problem is I was on my own at that point. And the judge said, do your cross. I asked for a break. The judge said, no, do your cross. And so I had to stand up, and thank goodness I had read this book about ballistics because I had all my impeachments and everything ready in there. And that's why from that day on, I was like, you know what? Before I get an expert, I'm going to vet the expert, and I'm going to make sure that I'm able to do this case with or without the expert. I'm not going to rely too heavily on an expert. And also, again, I'm going to say this again, be careful of experts that are cool, that are friendly, that are a good time to hang out with. You want an expert that's going to work for you and your client. Not an expert who's a frat boy that just wants to show up and drink shots all night long and tell war stories. You want one that's going to do research on the modern science, the modern literature, and that can testify soberly on the witness stand if you call them, and someone who's going to help you write questions. So again, I'm going to warn you, be careful with just going out and hiring an expert because I've been burned many times. Here are your resources. You want to go to Google, you want to look at past crosses, ask some of your colleagues about past crosses, go to databases, professional association websites, university libraries, journal websites. You want to go to government websites, any place that has authority resources based on who you're going to be questioning. So here's a little tip for you. Be careful with getting an expert who just throws out anecdotal information or articles that look like studies, whereas they summarize other articles or summarize other studies, or they're snippets of studies. If you're going to go out there and do research, go straight to the scientific journals and textbooks or official government manuals and things of that nature. Don't go to an article in the local, let's say the ABA journal. That is probably not, an article in the ABA journal about digital forensics is not going to qualify as a learned treatise exception, a document for impeachment. Okay, you could use the resources from there, but that is not, maybe an article in that magazine that has to deal with a legal topic, but I'm talking about articles that are written and put into different journals, magazines, and newspapers that don't have the authority of an actual journal article or a textbook, meaning they haven't been peer reviewed. It's sort of like anecdotal studies and things of that nature. Those aren't going to work, and they're not going to be considered a learned treatise exception in most situations. This sounds like a lot of work, right? Doing all this research, doing all this digging. It is. One thing that I recommend is that everyone watching this get a law student or college intern. You can get a law student. Sometimes they will get credit, like at local universities here in Florida. They'll give law students 4 credits for a semester of working, and they have to work 15 hours a week. It counts as a class. You got to mentor them and things of that nature, but you have someone like that at your disposal. Everywhere in this country, everyone watching this has access to an intern, a law intern that they can hire or get as a volunteer. And they have access to all these databases and to all this research right at their fingertips. They can do this from home. Just tell them, hey, I need an article. I need you to look up an article on M4 ballistics and penetration depths into plywood or something of that nature. If it's a shooting case. And somebody can go look to see if there's articles and pull them up and send them to you, both their abstracts and the complete articles. They can do that very quickly, save you time and money. And it'll give them experience. Talk about journal articles, legitimate ones. You want to go to things like Elsevier. There's the link there. They have a massive database of professional articles, scientific articles. Another one is National Library of Medicine. I use this all the time. You can get abstracts of most of these things without being a subscribing member. A law student has access to all of this. Your public library probably has access to most of this stuff too. I know LexisNexis and some of those other companies also have access, but let's say you don't have access to the database, you can go straight to their website. And then you get research articles like this. This one's on DNA. Let's say you're doing a case on whether or not DNA in sperm transfers after clothing is washed. That could come up in various cases, mainly criminal. And this applies to prosecution or defense, mainly criminal. But you get the article and then you'll get an abstract of it. I mean, we all know what abstracts are, but it's a summary of what the article shows or doesn't show. Another thing I use is manuals. And there are manuals for everything, whether you're doing car wrecks, whether you're doing, looking into how logs should be chopped down in a forest, best practices of pretty much everything is out there documented by some government agency. And so I give examples here of computer forensics, lab submission. I mean, these are all things you can turn into pattern cross-examination questions, whether it's criminal, civil, any type of litigation. Corporate resources as well. I mean, there's so many government and corporate resources online relating to medical issues, drugs, medical procedures, how, people at work should be trained on dealing with hazardous chemicals or step ladders, you name it, there's something out there, whether it's OSHA, whether it's the Department of Labor, Pfizer, there's so much out there, and these are your sources, okay? Here's another source that I've gone to quite a bit. Go to professional association websites. They often list speakers, and that's where you can find experts, and they also often list studies and interesting things that you can use as resources. So let's say you want to do American Psychological Association, you go there, see who the speakers are, see who's an expert in what, and you can often get some of their PowerPoints and information to use. So now we're going to turn the books, studies, and protocols and all this material into cross-examinations. It's easier than you would even think. This is a DNA example. It's a criminal case. So the defendant is accused of sexual assault on a bed. Semen is allegedly deposited on the sheets. The defendant denies the allegation. No DNA is found on the sheets or the victim, and no sperm is found anywhere. The sheets were laundered once the victim is bathed. So there's going to be no semen or DNA on the victim. The question is whether or not you would find the DNA or sperm on the sheets. So in this case, the prosecutor calls a DNA expert who wants to explain why there's no DNA or sperm found on the sheets of the defendant. And so this expert says, I would not expect the defendant's DNA to remain on the bed sheets because they were washed. So let's say you're the defense lawyer and your defense is, my client was never even in the room. He doesn't even know this person, never on the bed. You got the wrong guy. And now that the prosecution is trying to argue, well, it could have been his, but they washed it all away, right? You want to say, well, it could have been his, but you didn't find any DNA or semen, and there's a good chance you would have. So you pull up this study about the investigation of DNA and its transfer onto clothing, and you want to bring up 2 points. Laundering sheets doesn't destroy DNA many of the times, and the defendant's DNA was not found perhaps because there's never any semen on the bed. So basically to contradict the story. And so you find this article right here. You don't need to read all this, but basically the article says that DNA profiles from laundered semen stains were recovered after 8 months after they were deposited. So just so you know, Semen doesn't really wash off sheets. FYI to those watching this. Even after multiple washings, what it can do is transfer it. The semen can be transferred and the DNA can be transferred to other items of clothing. So if you have semen on a sock, you throw it in there in the family wash, you may now have semen on everything. It's kind of gross, but based on the testing, that's kind of where we are with the science. So what we did was we took this article that I was telling you about. So here's the point. Laundering does not always destroy DNA. And I'm not going to read this. It's in the slides because it'll take me a few minutes, but you can read along here and you could see that what you're doing is you're establishing your main point and then you're bringing up this article to their expert, the one who said they wouldn't expect to find semen on the sheets because it was laundered. And you get them to acknowledge the article. You get them to acknowledge that this is a legitimate journal source. And then you bring up the article and then you impeach them with the article as they apply to the facts of your case and as they applied and came out in the article. There has to be obviously some connection, has to be relevant. Here's how this cross would go. Now, I know you can read it, but I'm going to read it to you as you would ask the questions. This is of the prosecution's DNA expert. You testified that you would not expect the defendant's DNA to remain on the bed sheets because they were washed. That's correct. Are you familiar with the International Journal of Legal Medicine? It's helpful if you have the journal with you. This isn't it. This is something else, but as a prop, you have the article with you from that journal, and they know you have it. So they could either be thinking, I don't know what's in it. I heard of the journal. I maybe didn't read this article. So you move on to the next question. The International Journal of Legal Medicine is a leading journal for forensic scientists. Correct. The journal publishes articles about recent forensic research. Yes. Have you read the article titled Investigation of DNA Transfer onto Clothing During Regular Daily Activities? If they say yes, you're good. If they say no, you could always say, sometimes the judge might get mad about this and I'll explain how to deal with this later on. You could say, would you like to take a break so that you can review this article or not and just go straight into the impeachment? You then could follow up and say, this article is based on a scientific study about how DNA transfers. Correct. The results of this study were published in the International Journal of Legal Medicine. Yes. In this study, scientists examined whether washing clothes in a washing machine removes DNA from the clothing. Yes, that was the gist of the study. When this study, the scientists found that washing does not always remove or destroy DNA from clothing. Yes, that's what they found. The study found that stained clothing can still have detectable DNA after being washed. Yes. Given the sensitivity of DNA testing methods, complete and partial DNA profiles can be obtained from stained items that have been washed. Yes. If there was a sperm on a bedsheet before it was washed, it was possible that sperm DNA would still exist on the bedsheet after it was washed. Yes. Then you could apply it to this case. In this case, there was allegedly millions of sperms deposited on the bedsheet before it was washed. Yes. After it was washed, no sperm was found on that bedsheet. Correct. So that's an example of how you could use that study. And there's obviously many other chapters of cross questions you could ask. There are many more subsequent questions and follow-ups you could ask, but that's just a snippet of an example of one series of pattern questions that can be used for that sort of fact pattern. You could also use that same template for other types of questions, other types of experts. You really would just have to replace the journal article name, some of the data, and some of the facts. And then, it could be a fact, questions about blood. It could be a question about some medical procedure. And that's where we're getting the Legos here. These questions are like little Legos built into a house, and the house can be broken down and converted into something else. And so here in this situation, all of these questions could form the basis for future questions in future cases. Here's a drug use example. The plaintiff driver was in a car accident while under the influence of OxyContin. The defendant seeks to show that the plaintiff was warned to not drive while taking Oxy. What materials do we want to use here? Well, we're going to use the FDA warning labels that are given to the patient and on the pill bottle and the doctor's notes. Here are the points we want to make. We're the defense lawyer in this case, a civil defense lawyer. The point number one, you knowingly ingested OxyContin. You drove a car while under the influence of OxyContin. You were warned by your doctor to not drive. You were warned by the drug label to not drive. So, one of our resources, the package insert. This comes with every drug. They print this on the labels. They give it to you at the doctor's office. I mean, if you don't read it, that's kind of on you, but it's on the label the doctor tells you, and it's on the insert. So this is the package insert, which I got off of the manufacturer's website. You can get these for any type of drug or any type of medical procedure or device from the manufacturer's websites. Here's the drug example. Dr. Romano told you that OxyContin can impair your mental abilities. Yes. The warning on the bottle that he gave you said that OxyContin can impair your mental abilities. Yes. Now, let me pause right here. Obviously, this person can say, oh, I never read the labels, or the doctor never told me that. Got it, okay? This example is not covering every potential deviation. And if that happens, you could still impeach the heck out of the witness with the doctor, with the label, with all that, and just common sense. So, let me undo the pause and go back to the questioning. Dr. Romano told you that OxyContin can impair your physical abilities. The warning on the bottle said that OxyContin can impair your physical injuries or physical abilities. Dr. Romano told you that OxyContin may impair your ability to perform hazardous tasks. The doctor also told you that this drug can impair your ability to drive a car safely, that driving a car could result in serious injury, that driving a car could result in death. In this case, you made a decision to take OxyContin. You made that decision on January 25th, 2022. Then, after making that decision, you made a decision to get into your car. You got in your car after taking the OxyContin. You then made a decision to drive your car on a highway after taking OxyContin. The highway was I-95. Next section. When you drove that day, you knew that OxyContin could impair your mental abilities. You knew that OxyContin could impair your ability to think clearly. You knew that OxyContin could impair your ability to react. Now I'm going to pause right here. This is another example of breaking down a question into sub-questions to make a point. So we're going to focus in on impair your ability to react and make that a series of sub-questions. And you can do this with all sorts of questions depending on where you want to make your point, depending on the witness, how they're acting and where you are at in the case. So again, you knew that OxyContin could impair your ability to react. You knew that it could impair your ability to react to other cars. It could impair your ability to react to pedestrians. It could impair your ability to react to traffic signals. So you might be slow hitting the brakes if you saw a red light. So you knew that OxyContin, for example, could make you slow to react to a human being walking in the street. It could slow your ability and delay your ability to hit the brakes if you saw a child on a bicycle. It could impair your ability to hit the brakes if you saw a car stopped in front of you. You knew that it would potentially slow or impair all of these abilities when you got into the car. And you knew that because the doctor had warned you. It was on the warning labels. And this wasn't the first time you took the drug. You had taken this drug previous times, and those previous doctors had warned you. As a matter of fact, there's a sticker on the pill bottle that says, do not drive a car while taking these drugs. And you read that label. You've seen it many times. It's on the label that you have at your house right now. It's in bright yellow. It's in bright yellow, the label that says, do not take these pills and drive a car. Do not take these pills when operating heavy machinery because it can be dangerous or fatal. And you can kind of riff off of that, right? And then you can go back in your questions. You knew that OxyContin could impair your ability to make decisions. You knew that it could slow your thought process. You knew that it could cloud your judgment. Now, thinking, reacting, judgment, those are all things that are important to driving a car. Those are things that are important to driving a car safely. Those are things that are required of you to operate a vehicle at a high rate of speed. And that's what you were doing. You're operating a vehicle at a high rate of speed at 75 miles an hour on I-75. And that's the vehicle you were operating at the time of the crash. And that's the speed you were going at the time of the crash. And you were under the influence of this drug at the time of the crash. And then you could always elaborate. At the time you crashed, you were driving 25 miles over the speed limit at the time that you crashed. And you could just go on and on. Now, the foundation for these Lego blocks comes from the label, comes from the doctor's report, and it comes from the insert on that document. So you can do a pretty devastating cross. Now, this is just a little sample of a cross, okay? You can do a devastating cross if you're calm, if you're prepared, and if you write out and have these questions ready to go. You don't have to ask them verbatim by any means, but you should have the questions written out and at least the sections in the chapters ready to go. Here's a medical malpractice example. This has to do with the insertion of a feeding tube into a child. So the defendants are the doctor and the hospital. The doctor put the tube into the child, never checked the tube to see if it was properly placed, never x-rayed, never did anything, just stuck it in there and figured, because he knows it all, it's probably where it needs to be. And the hospital never followed the procedures to double check. And so this tube was then, the food was then leaking into the child's lungs, and it caused a severe infection in this case. And so the plaintiff sues the doctor and the hospital for negligence. So what are we going to use? We have a doctor who has all this education training, and you can assume they're going to bring in another doctor to talk about best practices. So what I would recommend here, in this fact pattern, is go to find the most up-to-date best practices that are reviewed and relied on. And I'm not sure if these are, because I don't do medical malpractice. This is just an example that a friend of mine gave to me. So we're going to use the Pediatric Nasogastric Tube Placement and Verification Best Practice Recommendations. Basically, this is a medical report article that looks at the best practices for making sure that tube is properly placed. And so you go get the article and you want to and see what it's going to say. And then if it backs up your side, you could potentially use it. So the points that the plaintiff wants to make here are x-rays are the gold standard for determining proper tube placement, because you can do an x-ray. An x-ray will tell you where the tube is, where if it's somewhere where it shouldn't be. I had a case actually myself where the tube was put into the stomach and it wasn't actually attached in the stomach. It was actually into the body cavity, and they were feeding this man food, and it caused a huge infection, killed him, got all up inside of his other organs and was like festering in there because the doctor in that case did not verify tube placement. So this is a thing, and you med mal people know it is. So the doctor not only didn't verify, he didn't order someone else to verify, and neither did the hospital. So what do? We go to this abstract, pull up the article, and this is just a little sample, okay, because I don't want to be reading things this whole class. The point, x-rays are the gold standard to verify feeding tube placement. So you have your article ready to go, ready to impeach if necessary, and you could ask these questions. The placement of a nasogastric tube, otherwise known as an NGT, in a pediatric patient is a common practice. Happens all the time. There is a potential risk for tube misplacement with each insertion. These are all easy softball questions. A misplaced tube could compromise the patient's safety. A misplaced tube increases the risk for serious complications. A misplaced tube increases the risk for fatal complications. A misplaced tube could have serious ramifications for the patient. An X-ray is considered the gold standard to verify proper tube placement. It's been verified by dozens of studies. You could have those ready. In this case, the defendant did not order an X-ray to verify the tube's placement. Or, in this case, your hospital did not verify the tube placement using an X-ray. That was a decision that your doctor made, a decision that your hospital made, and no one followed up to verify that it was done properly. Again, the sky's the limit. I could go on for months and months and months with examples of these cases, but it becomes so easy to do once you've done it and you have the materials. You literally cut and paste the article section that's relevant, and you can, put the page number and everything in there as a citation, have your impeachment materials ready to go. Here's one with workplace injury. So this employer runs some sort of a metal shop factory that does painting and cutting of metal and scraping, and they use chemicals and fumes and stuff. The defendant did not properly install the air cleaning mechanisms, the safety precautions, didn't give the employees the masks required to protect them. So the plaintiff suffers lung injuries at work, claims that the employer is liable because they failed to install proper ventilation and provide proper equipment. Okay, there's plenty of places we can go for something like this, but there are also regulations, OSHA regulations on point. And I don't do workers' comp. I'm just using this as an example of a source to go to and how to turn that into cross questions. So here we're going to use OSHA standards part 1910. And the point of this cross is that a respirator protects people from dangerous chemicals. That may be one of the elements you have to establish or one of the points you want to make. So here we go. We go to the OSHA website. We pull up this material. We look through it to see what's relevant. And then we cut and paste it into a Word document and then break it down into cross-examination questions, perfect it, shape, get rid of anything that's not necessary, turn them into leading questions, and here we go. Point: a respirator protects people from dangerous chemicals. Question: a respirator is a safety device. A respirator protects a person from inhaling dangerous substances. A respirator protects a person from inhaling dangerous chemicals. You could list the chemicals that are present in this factory, or that could be another section. Next question. A respirator protects a person from inhaling infectious particles. Respirators are among the most important pieces of protective equipment for working in hazardous environments. According to OSHA standards part 1910.13.4a, a respirator shall be provided to each employee when such equipment is necessary to protect the health of such employee. And then you can move on to your next chapters. Like, let's say you're cross-examining the inspector, the building inspector, the building owner, the business owner, the manager, whoever's in charge of this operation, and whoever's on the stand. So, final example, sexual assault case. Here, in this case, the victim accuses the defendant of sexual assault. A SANE exam is conducted within 16 hours. Several vaginal microabrasions and tears are found on the victim. The defendant says, yeah, we had sex. It was consensual. The prosecution then calls a witness, a sexual assault nurse examiner, 25 years of experience, who states on the stand under oath, vaginal injuries, in this case, are consistent with a sexual assault. So the defense, what are they going to do? They can call their own expert. They can use the textbooks. They can use journal articles. They can use a lot of things in this case, given this fact pattern. So the defense's point is this: vaginal injuries sometimes occur after and during consensual sex. So where do we get this from? So we're going to go to the Atlas of Sexual Violence. This is like the go-to book for sexual assault cases. It's written by some of the most renowned nurses that deal with sexual assault and sexual violence. Has a lot of pictures, has a lot of diagrams, things like that. If you're doing any sexual assault case, prosecution or defense, you should own this book. You can also go online and look at experts. So like this is Dr. Markowitz. She's a very famous doctor. She's a nurse, but with a PhD. She's probably the preeminent expert on strangulation, sexual injuries, stuff like that. She testifies all over the place, teaches it. She has a research grid that's found online, that shows all the studies, because she's a researcher as well, obviously a PhD, and she knows her literature. So she compiles the literature to make herself a better witness, but also you can use it to cross-examine her or other witnesses. So these studies all have to deal with injuries after consensual sex. And so what they did was they compared consensual to non-consensual, look for injuries. In a sex case, they use the acronym TEARS, T-E-A-R-S, to look for injuries. That's how the nurses and experts are trained. They're looking for tearing, ecchymosis or bruising, abrasions, redness, swelling. Like that's kind of what they're looking for when they look for injuries. So here are the questions. Your point is, in this case, vaginal injuries sometimes occur during consensual intercourse. Here are the questions. When a man and woman have consensual sex, there can be injuries afterwards. Vaginal injuries caused by consensual sex are similar to those caused by non-consensual sex. After consensual sex, there may be vaginal abrasions. After consensual sex, there may be vaginal redness. There may be vaginal swelling. There may be vaginal bruising. There may be vaginal tears. Now, that's the end of the chapter. You could go on and talk about other studies, examples, and really get into the statistics on that. In some cases, it's about 50% of people that have, man and woman that have consensual sexual intercourse, roughly around 50% are going to have some of these tearing, ecchymosis, abrasions, redness, and swelling after consensual sex. So what do you do if your witness, when you go in a case, you have to kind of wonder, is it better to have that witness fighting me every step of the way or just conceding my points? I would rather have the witness concede the points that I want to have conceded, particularly if they're an expert or someone of authority. So what do you do? These are some ideas. They don't work in every case. It really depends on the person, but these are just tips to keep in mind. Use psychological warfare. Figure out who the witness is. What is their background? What is their ego? Are they going to try to trick you? Are they abusive of the lawyers? All of these types of things. Are they actual legitimate scientists that just want the truth to come out? Or are they biased? You know your enemy and you know yourself. You will be victorious in more battles. And so sometimes I do this. Let's say I'm going to do that sexual assault, impeachment, or cross-examination that I just talked about. I could take either those questions and then give them to the expert with Dr. Markowitz's chart or with printouts of a textbook, or I could give the witness the drug insert. For example, if you're able to talk to the witness, you can give them the insert and have them read it, highlight what you're going to ask them. And sometimes I tell them, listen, I'm going to ask you these questions. It's on page 29 of this textbook. Here is the chapter. Here's what's going to happen. I'm going to ask you these questions, whether or not that was found in these studies. And if you fight me on it, I'm going to impeach you. I'm going to impeach you and read out of the book in front of the panel. Now, if the person doesn't have a lot of credentials, particularly, and it's someone who's really not even that great of an expert, that could intimidate them, and especially ones that are very good experts, they're going to know what's in these books, and they're not going to want to be, unless they can distinguish it, they're going to not want to butt too hard against those studies and those findings, especially if they can't. They may concede it for you and prove your point. So if I'm cross-examining an expert that works for the government, for like a crime lab expert or law enforcement or investigator, or in accident cases, if it's a state police accident reconstruction expert, and I have like materials, like their own manuals, I will sometimes, it depends, jog their memory with what's in there. For example, things that should be considered, looking at roadways and all that sort of thing. Give it to them so that they answer the questions. Now, if they're going to be hostile regardless, then maybe you don't want to give up too much, or maybe you could think if they have burned you several times in the past, then maybe you can give them a bunch of articles and they won't know which way you're coming from. And you can then impeach them with the ones that matter to you. It really depends on the witness. But I find that in most of my cases where I give the opposing witness, assuming they're supposedly unbiased, the materials that I'm going to question them about, sometimes they won't testify, or they will often concede what I'm getting at. And those that want to fight, well, then you're in for a fight and be ready to impeach them. Here's the takeaway. If the witness thinks you know what you're doing and what you're talking about, they will back off. And this works with all types of witnesses, experts, fact witnesses, investigators. If they know that you did your homework and you're more prepared than they are, and you know the file and you know the evidence, you know the science, they're probably not going to fight with you as much as you would imagine versus someone who doesn't know anything. Those witnesses will often run amok on an incompetent or someone who seems unprepared. And then you got to be ready to impeach. Now, impeaching witnesses in this situation, we're talking impeachment under the federal rules with the learned treatise exception we learned about on the bar for the bar exam and at law school. You really never see it that often, but I use it like I talked about in my origin story. It's a statement contained in a treatise, periodical, or pamphlet if the statement is called to the attention of the expert on cross or relied on the expert on direct. So the first prong is that it's called to their attention on cross or they relied on it. Second thing, this publication is established as a reliable authority by the expert's admission or by testimony or by another expert's testimony or by judicial notice. So you have 4 ways to get someone to admit, like, okay, this book on shooting incident reconstruction is a reliable authority. Okay, the standard for reliable authority is not that high. If it's published by a PhD ballistics expert who's worked for 30 years, it's a gimme. Most books that are published are considered reliable sources if it's relied on if it's a medical book or something of that nature. Obviously, some like generic self-published 20-page pamphlet by someone who has no background in education might not be. But a journal article is, especially if it's published by a legitimate source. And don't back down if the expert's like, oh, I wouldn't rely on that book, that I don't like that author, he doesn't know what he's doing. You can have the judge acknowledge, okay, looking at it, it's peer-reviewed, you met your standard, go ahead and do the impeachment. And so here are the elements, that it's a treatise, periodical, or pamphlet on the subject of history, science, medicine, or any other art or science. That treatise, periodical, or pamphlet is brought to the attention of the testifying expert during direct or cross. It's published, and it is shown to be reliable. And you can do it, like I said, through those different factors, through that witness, through another witness, or through the judge. And I've had judges take judicial notice of learned treatises in books, like that one about sexual assault. I had a doctor that was testifying, and he just kept saying how nurses, they're not as good as doctors. And he wouldn't give me that is a book relied on by sex assault nurse examiners, although it is the preeminent book. He just kept talking trash on nurses, which turned off some of the jurors, made the judge mad. And so the judge is like, he recognized it. And I just started reading passages out of the book. Now, that book does not go back with the jury. In the federal rules, you can read it to the jury and use it to impeach the witness, but you don't copy and paste it and send it back to the jury. However, I would have a copy of the page marked as an exhibit and the cover and some of the information copied as an exhibit for the appellate record if you're going to do that and have it ready for the judge. And often I would recommend, not often, but I do recommend you have the passages you're going to read marked, printed, and given to the judge and ready to give to the judge and opposing counsel from the get-go before you do it, so it doesn't look like you're bumbling your way through it. So that's how it's done. That's how the impeachment is done. And then we move on to the final slide. And this is something that I argue all the time in closing. Physical, forensic, and scientific evidence does not lie. People do. And I use that quote when the physical, forensic, and scientific evidence helps my case. And the witnesses are saying things that are bad for my case. And sometimes they clash. Now, I only use this quote if it applies. If the physical, forensic, and scientific evidence is bad for me, I'll find another quote, okay? But throw that in your little toolkit and use it as necessary. So that wraps up my class on pattern cross-examination. If you have any questions or have any suggestions, contact me here. If you need the slides, contact me here. That's my contact information. And I hope you enjoyed the class.